All right. So, hi, everyone. Good evening, and welcome to another amazing episode of our Real Fireside Chat series. Hi, Aline. It's good to have you on. So, we're making a start now, and as we progress on the call, people will join in. So, it's really great. This is a very interesting episode that we're having today. And it's really nice because we'll be having two legal experts on the call. And this is the first time we're having two guests on. So it's quite exciting to see how that goes. As usual, it's a fireside chat. So you're very welcome to put questions in the chat as we progress on the call. And wherever, if you have any comments, questions, pop them in the chat. And myself or our guest will be very happy to take them on. So we'll be kicking off with the conversation, and we'll be opening it to Chris and Alex, who are our guests, to sort of give us an introduction about themselves. What attracted them to the law field, any strong role models in their lives, so things like that. So we'll start off with you, Chris.
Yeah. First, Winifred, thanks very much for inviting us to attend this evening. We're really looking forward to the session. And please, everyone, feel free to ask questions as we go through. We're very happy to have an informal session and just to deal with questions as they come up as we go through. For me, my background was sort of entrepreneurial. I grew up in quite an entrepreneurial household. My parents were both self-employed, so I was exposed to business and people running businesses from a very early age. And I think that sort of got my interest into going into that type of world or that type of profession. And it was obviously pre-technology, so businesses that were a lot more straightforward than they are today, but it still gave me that exposure to business. And as I grew up and I was studying, I thought I didn't see myself as a business owner, because I wanted exposure to really different types of businesses and different industries and different sectors to really get a good broad understanding of how business works. And I started studying law, and I really enjoyed it. I found it, technically interesting and challenging, and I'm a bit of a sort of puzzle solver, I think, by nature. So the law sat quite well with me. And I think it was then that mix of that sort of early experience of business and then enjoying the technical side of the law that really made my mind up that it was the career that I wanted to pursue. And to be honest, it's been a great journey. I've spent most of my time in private practice, but I've worked in-house as well. So I worked as head of legal for an IT and engineering recruitment agency for a number of years. I worked as head of legal at University of East London as well. So I've done stuff in private practice, in-house, public sector, private sector, and it's just been great experience. I just really enjoy being part of that ecosystem of people doing interesting things and businesses particularly growing. I love seeing really interesting businesses, really passionate founders that have got great businesses that are high growth and are going through that journey of trying to grow, trying to expand, trying to find investment, seed investment, Series A, Series B, and going all the way through to exits or listings. It's just a great journey to go on, and to be part of that success story, I find really rewarding. So yeah, no regrets on my side. I really enjoy being a lawyer. It's been good so far, but I've got a few more years to go. So maybe we do this again in 20 years and I'll tell you how the whole thing played out.
that would be a lovely episode to do. So thank you for that. And I really do understand that, where you said your mind works like a puzzle, and you found law to be quite interesting. Because when I think about it as well, I'm an accountant by profession, and Sometimes when I'm doing some accounting work, I just really get the thrill. It really makes me excited. So I really did resonate with that what you said there about really enjoying what you do. So thank you for the introduction. So Alex, if you want to just sort of share your own experience as well as to what are some of the key attractions and whether you are enjoying what you're doing at the moment.
Yeah, sure. So I think actually hearing Chris's story then it's probably slightly similar and slightly different to mine. So I didn't grow up in a entrepreneurial sort of household. Every single one of my immediate family is in the medical field of some sort. So my sister's a doctor, my dad's a doctor, my mum's a nurse. So if they had it their way, I'm sure I would have become a doctor or something like that. But I don't love hospitals, so that sort of ruled that one out pretty quickly. So but I didn't really have a huge idea of what I wanted to do growing up, and I can't really say that I thought law would be my calling as a kid. And I went to university and I actually studied ancient Greek and Latin, which doesn't necessarily lead into any sort of particular career. So which was kind of good for me because it left my options open. But I just thought so this is where it sort of becomes a bit more similar with Chris is that I'm sort of a puzzle solver as well. I quite like trying to work things out. I'm by no means an engineer, but I like sort of fiddling with things and seeing how things work. And I think that tapped into that side of it. And I thought about law. I knew it was a pretty technical thing to go into and does involve problem solving of some kind. So I decided after I left uni, having done classics, I would sort of do a conversion course into law. I think once I actually started doing it, started experiencing the academic side of law and see what that was about, I got I could tell then that was much more for me. And then as I progressed and managed to get a job and did my training and went through it that way to the point I am now, just having those legal experiences has sort of solidified that position for me that this probably has been my calling, but without knowing it much earlier on. And like Chris, I think it's the day to day actually in a way that sort of really makes it good. Talking to people about their businesses, working out what makes them tick. And quite often I find actually that they're quite interested in what makes you tick. And it's sort of that mutuality that works quite well. And no day is the same. It's a bit of a cliche, but no day is the same. All the challenges we face, even though we see a lot of similar things, they are usually always different. They always have little nuances, and so you're always kind of kept on your toes. And that's what I quite like about it, really. So yeah, it's still going well. I think if Chris thinks he's got a little while to go, I've got much longer than him. So yeah, maybe we'll do a come back in 30 or 40 years
I guess.
and see.
I guess certainly, but wonderful. Thank you for that. And I know when I was sort of just going through your background, I saw ancient, Latin and Greek. I was like, oh wow, that's very, very interesting. I don't know. I don't consider myself to be a very good language person, but I think that's a lot to take on. But fantastic. Now, sort of moving into the core a bit more. So this question is for you, Chris. We're now looking into the areas of non-disclosure agreements, and this is where sort of you have an idea you want to share with someone else outside of the team or someone who doesn't know anything about this idea. Now, typically people would want the person that they're sharing this idea with to sign a non-disclosure agreement so that they feel like their idea is safe and that they cannot be taken away from them. Well, I remember seeing on LinkedIn, I think that was 2 weeks ago, there was someone that posted, I think he works with entrepreneurs, and he said if you send me an NDA to sign, I would not reply you, something like that. So I was like, how would founders take that? Number one. But also, people tend to say, a lot of entrepreneurs that I speak with tend to say, NDAs are not necessarily very important at the early stage, because most times developing an idea and commercializing it is a difficult process. So because it's a difficult process, what that simply means is people are not really going to copy your idea. So I just wanted to get your thoughts on that, on whether you think NDAs are necessary or not. And then we can build on that.
Yeah, so that's a great question, and it's one that comes up in practice for us. So Alex and I, in our team, we advise clients on a whole range of different types of commercial contracts. And it can be quite straightforward contracts. It can be terms and conditions of service, NDAs, IP assignments, all the way through to quite big outsourcing and IT project contracts. We also do a lot on data protection, and then a lot on IP. I saw there was a few questions in the chat from Peter on IP, so we can come on to those a bit later on. I think we'll talk about IP in a bit more detail a bit later. But yeah, on the contract side, the question about NDAs does come up. So I've had a number of clients that have said, I've got an idea. We've got an early stage business. We've really got a concept. We want to start talking to people about the ideas that we've got and the business that we've got, or that we think we've got. And what's the best way to protect ourselves? Should we have an NDA signed? And in reality, how much protection does that NDA give? I think, and the advice we always give is that it is good practice to have an NDA in place. The benefits of it are that you are, by having that document in place, you are ring fencing your confidential information. And you are saying to the party that you're sharing that information with that they can use it, they can look at it for the purposes of your discussions, so probably for some sort of commercialization, but they can't go and share it with unauthorized third parties. They can't use it for unauthorized purposes. And I do think it's really good practice to put that NDA in place and make sure both parties have signed it, so that you have ring fenced your information. And as the business matures and you do start to look at seed investment, later rounds of investment, I think an investor would be concerned if you'd been sharing confidential information and you didn't have any documents in place to show that you protected that information. So our advice would always be, right from the beginning, have a good NDA, have one that's drafted for you so that you know it's something that is in line with market practice. It doesn't have to be super heavy-handed, but something that has got all the key things in it that then you can go and present to third parties whenever you share information with them. That would always be our advice. When you're drafting that NDA, there's a few things that you need to think about. So do you want it to be a one-way NDA? Is it just you sharing information with the third party? Or is that third party going to be giving some information back to you? Is it a one-way NDA or is it mutual? And generally what we find is that mutual NDAs tend to be received better. So we would always say, have a mutual NDA that you can put in place. I think there is always a question about how beneficial NDAs are, because actually if somebody misuses your confidential information, it can be difficult to prove who it is that has actually misused it. So NDAs, they're good to have in place. Do they give you fantastic protection? Probably not. It can be difficult if your information gets leaked. It can be difficult to prove who leaked it. And it can also be difficult to prove that you've suffered some sort of financial loss as a result of a breach of the NDA. So actually your remedies for a breach of an NDA are quite limited. But what an NDA does, I think, is it has a deterrent effect. People think, oh, I've signed that document, therefore I'm not going to do anything that I shouldn't. And I think that is helpful. I think from a practical point of view, one of the most important things is just to be really careful about what information you're sharing. So really, from a practical perspective, just share the minimum amount of information that you need to. All of your sort of crown jewels, keep them close to you. Don't share them unless it's absolutely necessary, and minimize the information that you share.
Thank you very much, Chris. I really found that very, very enlightening. I'm making my notes as well. So it's really good to sort of hear what you have to say, because you'd hear a lot of people say, oh, don't bother with that very early on, because, running a like I said, commercializing an idea, it's not the easiest of things. So don't bother with it. But I think it's just like you said, it's quite important to, I think from a very practical standpoint, to be careful with what you share in the first place. Because as you've highlighted, it's very difficult to prove a breach of NDA. So it's always just practical wisdom to just be careful in the first place, but still have that NDA. But also, what about if you encounter a situation, like I said, I saw online, where you've asked someone to sign an NDA and they say no? How do you advise that the founder goes about that kind of situation?
Yeah, so if you can't get an NDA signed, then I think firstly I'd be suspicious as to why the other party doesn't want to sign it. So I'd be very careful or wary about dealing with somebody who won't sign an NDA. If you feel that you do still want to, then I think it's really important to limit what you share with them. Don't give them anything that's too sensitive. There is a general law of confidence. So the common law does protect confidential information, but it can be quite risky to rely on the common law. And it is much better to have an NDA or a contract in place that protects that information. I have heard the argument run in the past where somebody will say, well, we don't need an NDA because the common law of confidence will apply anyway to protect your information. But actually, yeah, as I say, the common law is not great, and we should always be pushing to have an NDA in place.
Fantastic. Thank you very much, Chris, for that answer. Now, moving on to the next, again, we're still on sort of contractual design and stuff like that, NDAs, and that is where Chris is going to be focusing on. So we're going to come to intellectual property soon, and that is going to be taken by Alex. So when we come to that, we'll be able to take your questions, Peter. So if you bear with us, we'll come to your questions very soon. Now, my expertise is entrepreneurial finance, and I do work with a lot of entrepreneurs, and one of the first things, especially the early stage founders, is they're keen to know how they can raise finance. And I'm always cautious about that in terms of the advice that I give. I'm always like, first of all, I'll advise that you bootstrap at the early stage. Prove that this concept works first before you go out raising money. And so bearing that in mind, we just want to have an idea from a legal perspective of how the finance process works. Now, typically when an investor says, okay, we're going to give you some funds, there's usually some kind of due diligence that is done. And most times I think that founders are not ready for what that looks like, because most times they might not have what the lawyers are asking them to have in place. They might expect it to be faster, but it takes a bit longer than anticipated and things like that. Do you just want to shed light on what a typical due diligence process looks like?
Yeah, happy to. And we do lots of work on due diligence. So we've got a pretty big corporate team, and Alex and I and other team members will support lots of transactions where there's diligence. So we'll look at lots of businesses in terms of commercial contracts, data protection and IP, and we'll often advise investors and buyers on what the business should have in place when we're doing the diligence. So we're really familiar with it. I think what you said at the beginning, Winifred, is that's great advice on bootstrapping and sort of avoiding investment until you've really built the concept out and you're ready to move to the next stage. Sometimes I do think founders are in a rush to get to investment stage and to get financing. And I think it is good advice to say, just slow down, take your time, build the business first. I think the other thing as well is that once you take investment, sort of life in the business does change, because you go from being a founder who has a lot of freedom to run the business as you want to suddenly having an investor looking over your shoulder who has certain demands and requirements in terms of return on the investment. And it does mean, as you know, the whole dynamics of the business change, and you've got to be really ready to make that step. But yeah, in terms of diligence, so the process that gets followed does tend to be, it's quite a formulaic process, really. And you sort of follow various steps for any type of M&A transaction or for an investment. And the level of detail that we go into as part of that diligence depends on the transaction. So if it's a sort of smaller investment, it would normally be a red flag due diligence, just looking at the real key issues. But if it's a sort of larger business and an acquisition, then quite often we get asked to do a very detailed review of the business as part of the due diligence and to really do a deep dive on the various aspects. So it can be quite a detailed and long process to go all the way through from beginning to end. But broadly, the steps that you'll follow are that at the beginning, there'll be some initial due diligence questions, which get asked of the founder. And they'll cover all different parts of the business. They'll cover contracts, data protection, IP, employment, real estate, disputes, finance. And the founders will work through those due diligence questions and complete all of the responses. There'll then be a data room that's opened up so that the company and the founders can load all of the relevant documents up into that data room. So normally, investors, buyers will ask to see, for example, they want to see the top 10 customer contracts that the business has, top 10 supplier contracts. They'll want to see all of the key documents around IP. They'll want to see the employment contracts for the founders and any key personnel. So all of those documents will get uploaded into the data room so that the buyer and the investor, or the investor and their advisors, can go through the documents, review them, and assess the risk and the position of the business. There'll normally be some further rounds of due diligence questions off the back of that. So naturally, as you go through the documents, you have further questions. There'll be a deeper dive, and there may be some further rounds of questions that come out, which the company and the founder will need to answer. Once all of those questions have been responded to and everyone's happy with the answers, then the transaction documents will get drafted up. That'll be either the share purchase agreement or the investment agreement. And those documents will contain a bunch of warranties, which the founders are asked to sign up to, warranting that certain things are true. For example, giving a warranty that the company has never broken the law, a warranty that the company's complied with data protection obligations. And those documents will then get signed to complete the transaction. And then usually there'll be some pre or post completion actions that need to be taken. So, for example, if we as lawyers advise that the company doesn't own all of its IP, maybe some IP has been created by a third party and hasn't been properly transferred to the company, then probably one of the pre-completion actions will be to go and get a IP assignment executed to ensure that the company owns all of that IP. So there'll be pre-completion undertakings, post-completion undertakings, And probably for about 6 or 12 months afterwards, the founders will be doing some tidying up in the company to comply with all of those post-completion undertakings.
All right, great. Thank you very much. Oh, did I stop you, or should I carry on?
Yeah, so well, I was just we could talk through, if it's helpful, a little bit more detail on the sort of specific things that we see on some transactions. So
I think
around
that'll be
contract
great. Yeah, I think that'll
data,
be very
you know,
helpful.
based on our experience, sort of what it is that investors and buyers really care about, because we see this all the time through relationships that we have. I don't know, Alex, I know you've worked on lots of deals recently over the last couple of years. I don't know, do you want to share some of your experience on key themes?
Yeah, sure. So, Chris, as you said, we act for buyers, we act for investors, but we also do act for sellers and investees. So we see it from both sides of the table. We see due diligence from sort of both sides of the coin. But it is the same. A lot of the same things do seem to pop up. And as Chris said, the due diligence process is going to cover all areas of the business. So employment, commercial IP, data protection, tax, and things like that. But Chris and I focus on the commercial IP and data protection side of things. So yeah, if I'm happy to talk through some of the most common things that we see, some of the most common pitfalls and issues that arise. So if I start with commercial, probably a bigger picture point around a commercial is whether written contracts are actually in place. So that could be contracts with third-party suppliers, it could be contracts with customers, contracts with business partners. One of the sort of major pitfalls we see, particularly with early stage company, is that there just aren't written contracts in place. So kind of understandably, cost can be a big factor when it comes to early stage companies, and what they don't want to do is have to pay lawyers to draft complex contracts or draft contracts to put in place. And so sometimes they've got relationships that have grown over a number of months or potentially a number of years, and they're contracting on the basis of a sort of a gentleman's handshake. So there's no written contract in place, but they sort of, this is how we've always done it. I trust this person and they trust me, and that's the basis on how we're going to contract. But that's all well and good until it goes wrong. And as lawyers, we would always advise that written contracts need to be in place. There needs to be a written document that appropriately governs the relationship between the parties. And if you don't have that written contract in place, well, the sort of ambiguity can lead to disputes. What happens? You may say you trust that person, but what happens if one day they go, actually, I don't like the way this is being done. I'm not going to supply these goods to you in the same way I have been for the past couple of years or couple of months. I'm going to do it in a slightly different way, but you're not happy with that. But then there's no contract in place that imposes firm obligations on the supplier to do it in a set way. So it can lead to disputes. But that also means that there's sort of a lack of commercial protection for the business, and it sort of overlaps with various other areas of law like IP. So if you don't have the proper contracts in place, how can you properly protect your IP? There's not going to be any written provisions in place. So bigger picture is, have you actually got written contracts in place? Try as much as you can to avoid a sort of gentlemanly handshake type contract. And then the second point on the commercial side of things that's worth mentioning is, even if you do have written contracts in place, which is great, that's the first step. Have you got the correct provisions within those contracts? Are they drafted in the right way that are going to protect the business? And the type of things that investors and buyers are going to sort of drill down into if they're provided with written contracts in the due diligence process is they're going to look at the sort of liability provisions. So what's the liability provisions for the company? Have they appropriately limited their liability under the the agreement, that could be by way of a financial cap on their liability. So the company's liability is limited to £100,000 for anything under the terms of this agreement, subject to things that you can't always exclude your liability for. Investors are also going to be looking at termination provisions. So if, for instance, it's a contract with the business's main customer, what you wouldn't want to see is the customer having really broad termination rights. You wouldn't want to see that key customer being able to terminate just sort of the click of their fingers and say, we can give you 5 days written notice to terminate the agreement and then we can walk away. You want a bit more sort of security around locking in that key customer for a longer period of time. And it works both ways as well. If you've got a supplier contract that is potentially unfavorable to the target business, what you wouldn't want to necessarily do is be locked into that contract for too long. You want to have ways out of that contract. So it's going to depend on what way you're looking at it, but liability and termination are certainly some of the key areas that investors and buyers are going to be looking at when it comes to contractual DD. So those are some of the main things on commercial. If we move on to IP, again, sort of starting off with some more bigger picture point, it's about understanding and identification of IP. What I see quite a lot of is when we send out the due diligence questionnaire, so the initial questionnaire that founders have to fill out. There'll be questions around IP that broadly sort of say, what IP do you have in the business? What's your core IP? How is that made? And a lot of the responses we get are sort of NA or there's no copyright in the business, as an example, when actually that business is centered around a piece of source code for an online platform, and that's their main offering. So there most likely is going to be copyright in that code for that key platform. And so when you see things like that, it sort of indicates that the business doesn't really understand their IP. They don't understand what IP subsists within their business, and they haven't identified it. And if you sort of don't do that initial step, you're never going to know how to protect it. You're not going to know how to expand it as well. So do you know what you own or what you believe you own is certainly a very key thing that investors and buyers will look at. And then following on from that, even if you do sort of understand and have identified your IP, yes, we believe we've got copyright in our source code for our platform. Do you actually own that IP? And this is one of the key things. And it's something I see a lot. And it's around ownership of IP. And specifically when it comes to these things in the due diligence process, it's a lack of ownership of IP. A lot of businesses believe that if they've sort of said to a contractor or a third party, you do this work for me, I pay you, and therefore I own the IP. They think that sort of is it. That's sort of a bulletproof position around ownership of IP. And it's not always the way. It's quite a nuanced thing, ownership of IP, and it can be quite tricky to get right if you don't have the appropriate provisions in place. And one of the things that's actually probably worth mentioning is there's a distinction between employees from a UK perspective. There's a distinction between employees and contractors, and the IP position is not the same for them. So under English law, if an employee creates something during the course of their employment, the IP within that creation will by default vest in the employer, which is great. That is not the same for third-party contractors. So a third-party contractor creates something in the course of working for a business. That business will not own the IP that the contractor creates as default. As default, the contractor will own it. So it's important to have written agreements in place. And this is sort of a common theme running through it, having written agreements in place, appropriate provisions in place with both employees and appropriate provisions in place with contractors that ensure all IP has been properly transferred to the business. And as I said, that's a really key thing that investors and buyers will look at, because if the business doesn't own the IP it believes it owns, as Chris said, it could lead to some sort of pre-completion steps whereby they need to put the right provisions in place. But in an absolute sort of doomsday worst case scenario, it could actually be what we sort of call a deal killer. Or it could affect the valuation of the deal itself. So these are really important things to get right, because certain investors will sort of take one look and go, you don't own the IP, which you believe you own. The IP is really key to your business, and that's why we want to invest in your business. And because you don't own it, we just can't take that risk, and we're not going to, complete this financing. So really key to get that down. And I'll move quickly on to DP, data protection, which is everyone's favorite subject. But this is probably the most common pitfall with this one is actually people sort of forget about it and don't think about it until it's probably a little bit too late. As particularly with early stage companies, they don't really want to think about data protection, but it's not a fun thing to think about. It's not a key offering really of businesses, data protection compliance. It's seen as a burden. And the truth is there are some really quite complex laws around data protection. So one of the key pitfalls here is that it's just fallen by the wayside, and people haven't really thought about data protection compliance. But it could be a really key area, particularly if early stage companies are sort of focused around handling large amounts of personal data. So those are in health sectors, or those that are in the education sectors. Personal data and data protection and compliance is going to be a really key thing to get on board with. And partly the reason I say that is because the risks of fines and reputational damage can theoretically be really quite high, and quite punitive in a way. So under UK data protection legislation, there is a risk that if you're not compliant, usually only for serious breaches, but theoretically, if you're not compliant, you could be fined up to £17.5 million, or 4% of your annual worldwide turnover, whichever is greater. And a fine of that level could really ruin businesses, even established businesses, let alone sort of early stage companies. And in reality, we're not really seeing fines of that level being handed down, but that theoretical threat is always hanging above companies that aren't compliant with data protection legislation. So it's really key to stay on top of it, even though it's not a fun topic. So from a due diligence perspective, what are investors looking for? What are buyers looking for? I think number one is just showing and demonstrating that the business has actually thought about data protection legislation, how it applies to them and how it applies to their activities. Has the business got a general understanding of the data protection legislation and its obligations? And bearing that in mind, has it put in place a suite of internal documentation that it's required to do in accordance with data protection legislation? And has it got in place a suite of external sort of customer or supplier facing documentation, which again, some of which is mandated by data protection laws? So yeah, definitely a key thing there is actually proving you've thought about it. So that was quite a quick sort of whistle stop tour of the key things we see. Obviously, investors and buyers will look at other areas within the commercial and IP and data protection sort of brackets, but those are probably some of the key things that we see as being the sort of major pitfalls.
I was just going to add, Winifred, that I think it's really important and what Alex has talked about is great, and it's exactly what we see. It's really important for business owners to think about due diligence and the process as soon as possible. So even from those very early days when you first start the business, try to think ahead. Think, in 2 years I want to get to my seed round. 5 years I want to be getting later stage investment, and try to always look at the business through the investor's eyes. And prepare yourself for that diligence process. Put the contracts in place early. Do your data protection compliance as soon as you start collecting data. Because if you leave these things, it's very difficult to go back later on and try to fix it. It ends up being a really big job.
Thank you. Thank you so much. There's just so much to unpack from what Alex and Chris have said there, but I'm conscious of time and I know we've got questions to get through. And I think for Alex, what I quite found interesting was the contracts that you have with employees and contractors, and where, how that can differ significantly from the perspective of who owns the IP. I think that is very, very important for business owners to know, so that, when it's an employee, that then you own the IP, but if it's a contractor, it's a whole different scenario. So thank you very much for highlighting that. Now, I'll just start off with the questions, Alex, because you've sort of touched on IP briefly, and I'm going to ask you some questions that were put in the chat early on. So Peter has put 3 questions in. What steps should I take to protect my intellectual property? That's the first one he's asked. And maybe we'll take 2 questions. And the second one says, what are the potential risks and challenges I may face in enforcing my intellectual property? So Alex, we'll leave that open to you to answer it, briefly in any way you see fit.
Yeah, sure. So question 1, what steps should I take to protect my intellectual property? It partly depends on what the intellectual property is. So if, for instance, it's an invention, you could be thinking about patentability. If it's a logo or a brand name, you could be looking at trademark protection, registered trademark protection. So it does depend on what the IP is, because various different pieces of IP will have sort of different rules around them and different ways to protect them and get the best out of them. But probably the answer here is some of the things we've probably already touched on. So thinking about the NDAs really early on and confidential information. If you want to be protecting your IP, you need to be ensuring that it's only in the hands of people who need to know it or need to use it in some way. And similarly, written agreements are really, really important. Whoever it is you're sort of contracting with, or if you're giving IP to people. So if you're licensing your IP out, you need to be ensuring that you have a proper written contract in place that ensures it's clear that you own all the IP, you remain the owner of all the IP, and there are certain restrictions on what the licensee can do with that IP. So they might only be able to use it in a specific territory. They might only be able to use it for a specific purpose, a very narrow purpose. And for instance, it could be a non-sub-licensable, so they don't have the right to sub-license to anyone, and they don't have the right to transfer it to anyone. So it's quite a broad question. What steps should I take? As I said, it does depend on sort of what the IP is, and once you've worked that out, you can sort of tailor it a bit more. But I think certainly there's some of the things we've talked around NDAs, around making sure you have the written provisions in place, and people that have using the IP only have the right to use it for certain things, and it's in the right hands of people that definitely need to use it. You're certainly on the right track to ensuring you're protecting your IP. And then, sorry, the second question. So What are the potential risks and challenges I may face in enforcing my intellectual property? So again, sorry to sound like a broken record. It is going to depend on what the IP is. There are different rules around enforcing a trademark compared to enforcing a patent. But there are definitely some sort of broad challenges and risks. So a challenge could be a cost. Sometimes it's actually quite difficult to enforce your IP because of the costs that are involved, and that could be the costs of myself and Chris. We exist for a reason, to help people and to advise people in the best way we can. But lawyers can be costly, and that can be a challenge, particularly for early stage companies. And certainly if we're thinking about costs as well, if the other side, if the potential infringer, the alleged infringer that you're hoping to enforce your IP against, doesn't want to play ball and they're going to fight back, and maybe they've got a particularly litigious appetite. They want a sort of fight around the IP and are going to drag it out. That can be a real strain on resources, time, effort, as well as a sort of financial burden. And in terms of risks, it does depend on the IP. But if I try and think of an example, so a registered trademark, you believe someone is using your logo or your brand name, and you say you want to enforce your rights against them. It's entirely possible that they challenge your right. So they might say, yes, you have a registered trademark, but your application was made in bad faith and you shouldn't have been given a registered trademark. Or we have something in the UK called a use it or lose it system. So if you don't use your registered trademark within 5 years, third parties can apply to cancel your trademark. So there's the risks of people filing sort of counter measures against any enforcement action you take. So before you take enforcement action, you need to think carefully. You need to sort of think long term. You need to be thinking, if this does get dragged out, what are the costs going to be to me? What are the type of actions that the alleged infringer might take against me? And there are sort of a whole wealth of factors to consider there. But I hope that sort of briefly and helpfully answered the question, Peter.
I'm sure it did. Thank you very much, Alex. That was very, very clear and just very well understood and very well communicated. So thank you very much. Moving on, so I have some questions for you, Chris, and this is regarding to NDAs. So Alina has asked a few questions. So she said, in relation to NDAs, when do you think it is best time to inform a potential investor or associate about the necessity to sign an NDA? What if you meet for a coffee and discuss about it? So she's put in 3 questions, and you can take them as you like. Maybe we start from the first one, but we're just mindful of time. And before we carry on, very quickly, if you're based in the States, please pop your name in the chat, because we'll have to do a separate giveaway for you. So Chris, over to you.
Yeah, so I would absolutely have an NDA in place as soon as possible. As soon as you start having those conversations, it is best practice to have that NDA in place to protect any confidential information that you might share, even if it is over a coffee. And I don't think an investor would be concerned about that. I think it's good practice to put an NDA in place. And I think an investor, a reputable investor, would be perfectly comfortable to sign up to an NDA before engaging in discussions with you about your business or your ideas. So yeah, I would say as soon as possible.
Aline, so there's a second question, Chris, so I'll just read that out. It says, what are your recommendations when it comes to discussing about a pre-launch phase of a business? What are the aspects that we should absolutely absolutely avoid unveiling, even with an NDA. Because again, remember, we went back to that practical wisdom of saying, because you've highlighted that breach of NDA is difficult to prove, so be careful with what you share. So I think she's wondering, how do I know what is too much and what is okay? So
yeah, it's tricky to know the balance, isn't it? And the general rule is disclose as little as possible. But I appreciate you also need to get the interest for them from the investor, and you need to explain the business and get their enthusiasm going. So it's getting that balance right. I suppose you can take a couple of examples at opposite ends of the spectrum. I think if you're sitting down with an investor and you're explaining what the business is, how it works, what the concept is, what you see as the market opportunities, maybe predictions around the revenue, those types of things, I think are all perfectly fine to share with an investor. I'd have the NDA in place first, but I think those types of conversations are absolutely fine. And they're conversations that you have to have. At the opposite end of the scale, if you'd started developing, let's say you had your business was based around a technology platform, and the investor said to you, I want to have a look at the technology platform. Can you send me a copy of, the code, including the source code? That would be an absolute no. That's at the other extreme end, where that is you sharing your crown jewels with that investor. So I wouldn't do that type of thing. But sharing general information about what the business is, I think if it's a technology business and you sat down and you wanted to, you had a laptop and you wanted to show them the product and how it works on the screen, that's fine. That's all part of the normal conversations. But you don't want to share any of the actual assets.
okay, fantastic. And then we'll just round up with this. Again, this is regarding to IP. And so we'll help this over to Alex. Alex, regarding the IP rights, now with the utilization of AI rising, how could we ensure that we own the copyright for a character designed with the help of AI through an app, when basically anyone could potentially create the same thing with the right combination? So I think that's a good question. So over to you, Alex, and just
Yeah,
what you think.
it's a great question, and a very complex area of law, to be honest. So maybe the first thing to say is actually, um, two individuals can create exactly the same thing, completely separate of one another, and not infringe one another. And the reason for that is copyright, as it sort of it says in the name, is really to do around copying someone else. So if you haven't copied someone else, there's not actually going to be an infringement. So two separate people can create exactly the same thing, provided they have done it separately and sort of unaware of the other person. When it comes to copyright in materials that have been created with the help of AI, it's a tricky area. It's quite a nuanced area, and it's probably better to talk about that offline. But what I would say is that individuals can still own the copyright, even if they've used you created something with the help of AI. But the UK is probably one of the only areas and one of the only jurisdictions that copyright can subsist in computer generated works. And if it's deemed that copyright has subsisted in the computer generated work without any human involvement, then there are quite specific rules on who owns that computer generated work. And it might not be the person who was given the instruction or sort of inputs the data into the AI. It may be the person that has created the AI in the first place. So if you want a picture of an apple from a piece of AI, the AI is going to use all the other pictures of the apples that it already knows in its AI brain to create that picture of the apple. So it could be around who has put all the pictures of those apples into the AI in order to create that apple output. That's quite a niche example, but it goes to show that it's a very complex area of law. But ADI, sorry if I've butchered your name completely there, but very happy to discuss that if you want to get in touch with us.
Okay, thank you very much, Alex. That's very generous of you and Chris. And I do agree, it will be a whole complex. And I think that's with the advancement of technologies, we're going to see much, much more complex transactions as we go. But we're now towards the end. And before we round up, we usually have our giveaways. Now we have Dion from the States, so automatically she's the only one that has called in from the States. So she's going to get the American giveaways. Now on my side, I'm going to do the spinner, and the spinner is for us to give out the 2 Amazon vouchers. So I've sort of put all the names in. I have 44 entries now. Some people might have dropped off the call, but I've done my best to try and get everybody on there. So I'm going to spin this now. All right. So Bill Pendley, if you could please put your name in the chat and then I'll get in touch with the Amazon voucher. So that's one £30 Amazon voucher gone. So we do for the second one. Rohit. Rohit the second time. Let's see. I don't know if Rohit is on the call, but let's see. Okay, so Rohit has won it the second time. All right, Rohit, let's see. Let's make sure because he has to be on the call. He's a student of mine. He has to be on the call for us, for him to be able to win it. So I'd have to double check to see that he's on the call. Uh, let's see, Rohit, are you there? PQR. No, unfortunately. So we have to spin it again. It's only fair that it goes to someone that attended the session. So Isabella. So Isabella. Isabella has dropped off the call as well. Again, with spin. Sorry for this, but I think it's only fair to give it to someone that is on the call at the moment. Henry. So Henry, again, I think a few people have dropped off the call, but I think we'll just one more time, and this is the final one, and then we finish. So as we do this final one, Chris, we'll come to you for some final comments before we go, just to close up the call, to share some final comments before you go. So this is the final one I'll do. Whoever gets this, I think we'll just give it to them. So Zach, okay. Zach Brown. Zach was on the call till up until now, so we'll give the second one to Zach. So we're going to stop here. So thank you very much for your patience. So Chris, over to you if you want to leave us with some closing comments, and then we come to you, Alex, and then we round up the call for today.
I think for me, just to summarize really what we've said, that really important for businesses to have NDAs in place at the beginning from that very early stage when you've got your idea and your concepts. And if you're talking to people, make sure you've got those NDAs signed, and always have one eye on the future and where you want to get to with investment and maybe a sale at some point in the future. And just try to put yourself in the investor's shoes or the buyer's shoes. If they were looking at your business, would they think it was well run in terms of, do you have all the contracts in place? Are you data protection compliant? Have you got your IP identified and correctly protected? So just have that eye on the future and the potential due diligence exercises that you're going to go through. Those are my 2 tips.
Okay, great. Thank you very much, Chris. Over to you, Alex. Do you want to leave us with some words?
Yeah, sure. So I think from an IP perspective, the key things really is understand your IP. Make sure you really have a good grip on what IP subsists in your business, what IP might subsist in your business, and as Chris said, having a long-term plan, how that IP might look in 5 years, not just now. And then the second thing would be ownership. Ownership is absolutely vital. You want to be ensuring you own the IP you believe you own. And to do that requires those written agreements in place, having the appropriate provisions to ensure that everything is properly transferred to the business. So the two things: understanding your IP, knowing what it is, and then two, making sure you have that full ownership of it.
Fantastic. Thank you. Fantastic. This has been an excellent conversation. I'm very grateful for your time and your expertise and your preparation as well. It's just been amazing. We had 44 people at some point on the call, so I'm sure everyone benefited from the call. This is our last fireside chat for 2023 until we meet again in 2024, January. We hope you have a very good Christmas. Thank you, Chris. Thank you, Alex. And once the recording is ready, I'll send it over. Thank you and enjoy your holidays. Bye.
Thanks, Winifred.
Bye.
Same to you.
Same. Bye. Bye.
Bye.
Isabella, if you're still on the call, Isabella, could you pop your email address in the chat, please? Isabella? So that I've received Penny. No. It was Bill Pendley. Bill Pendley won the fireside chat, and then Isabella, because Zach is not here. So Isabella is on the call. We'll give it to Isabella. So Isabella, if you could please pop your email address in the chat. So our two winners were Bill Pendley, and Isabella Ava. Okay, Bill Pendley and Isabella Ava. All right, we're going to stop the call now. If I can email you guys, as long as you've registered, I have your email addresses, I'll be in touch. So Bill Pendley and Isabella Ava. Right, so bye everyone.